Court rise in favour.
Yes, Mr. Wild.
My Lords, my Lady, may it please the Court, I appear for the appellant, Mr. Thatcher Mustaj. My learned friend, Miss Jackson, appears for the Secretary of State. Just by way of housekeeping, you should have a core bundle that the Court put together.
Yes.
There appears, and I only noticed it yesterday, that there's a document that has found its way in there that shouldn't be there because it's got nothing to do with this case.
Oh.
So you can happily ignore it.
Out of curiosity, I didn't notice it, but that just shows I didn't read the papers properly.
So unfortunately, the core bundle is not paginated at the bottom in a logical way, but it's PDF page 100 is a refusal of an EEA family permit for someone who quite obviously is not Mr. Mustaj.
Okay. Well, of course, I only go to where I'm referred to in the skeleton argument. So there is. Right. Thank you.
So we can happily reduce the page count by 2.
Yes, and then we've got a supplementary bundle, which is, in our case, not actually separate. It's in the back. But...
Yes, that's right. And that's just by way of what was the subjective evidence before the FTT going to the qualifying relationship, which goes to ground 1, of course. The only thing missing from the core bundle is the Secretary of State's skeleton argument, but we've
got that separately.
Presume you have that separately. Yep. And then finally, housekeeping. There's one correction in my skeleton. You will have seen reference at paragraph 6 to Section 85 of the 2002 Act.
Yes.
Section 85 doesn't apply to an EUSS appeal, but Regulation 9 uses
you'll
the exact
take us
same
there when we're there. Yes, I was puzzled, but I thought it would all become clear, so I didn't follow it up.
Just for your note, my Lord, it's page 256 of the authorities bundle.
So, I had some problem with the page numbers in the authorities bundle, which didn't seem to correspond to the index.
No.
But as long as we all have the same one, yes, I see there does appear to be a Regulation 9. So
Regulation
that's
9.4. The relevant authority may also consider any matter which it thinks relevant to the substance of the decision appealed against, including a matter arising after the date of the decision, which is transposed language word for word from Section 85. So the principle that I rely on is the same. The source is not the same. For that I apologise, but
well, you'll remind us of that when
yes.
you get there. But thank you.
Now,
incidentally, there's water under the bridge now. We don't have what the rules call a replacement skeleton argument. Let's say we don't have a skeleton argument from you with, possibly not from the Secretary of State either, I can't remember, with all the page references to the bundles.
No, my Lord.
That
not.
should have been filed.
I'm terribly sorry about that.
No, well, don't worry. Something to learn for next time.
Yes.
But that is actually, I'm not going to go on about it, but it is, especially here, where the rules are quite difficult to find, page references saying where things are essential, and the rules do provide for a skeleton argument once the bundle has been prepared for a new skeleton argument, which can be identical in substance, but just has the references put in to be filed. So,
if it would assist the court, I'm happy to do that after today.
Well,
but
no, I think unless my Lord or my Lady want one, I think we've got there now. But
well, I am sorry.
I would get that off my chest.
That was an oversight.
Yes.
Now, so those are the housekeeping matters. In terms of the background facts, they're not particularly complicated in this case. Probably the only thing that's not...
I think you can take it we know the background facts. Obviously, if there are ones you particularly want to emphasise for some reason, I'm not stopping you, but don't feel you just have to go through them for the sake of it, because we do know them.
My Lord, no. Well, what's the only background facts I will take you to in the context of my submissions on ground 1 are going to be what the evidence was before the FTT.
Yes, well, better done at that stage.
But I'll do it at that stage. Now, in terms of my structure, whilst obviously my ground one is the status of the relationship point and ground two is the AAA point, my learned friend and I are both going to take the arguments in reverse order.
I hoped you would do that.
And deal with the AAA point first. There are obviously logical and sensible reasons for that, but we like to be longer on AAA, and we accept we have to succeed on AAA to
You have to succeed on both grounds.
on both grounds, yes.
Yeah.
But AAA is the wider point of importance as well.
Good.
So, turning to ground one then, on the AAA point, you have it in my skeleton argument from paragraphs 30 onwards, and how I intend to address it is to positively advance our, as I would call it, positive case, and then follow up with responses to what the Secretary of State says in her skeleton argument in terms of how the Secretary of State says that the particular provision of AAA should be interpreted. Now, we know, obviously, following two decisions of the Supreme Court and the House of Lords, Mahad and Odolola, inform us as to how the immigration rules are to be interpreted. You have Mahad, paragraph 3, page 377.
But again, if there's things you particularly want to draw our attention to, obviously do, but they are very familiar.
Indeed, my Lord. Just perhaps one
Yes.
particular point then on Mahad, because
Which page did you say it was?
so that starts at page 377 of the authorities bundle. It is paragraph 10, which starts at page 383 and goes on to 384. And just to highlight two further parts of paragraph 10, which are not expressly highlighted in my skeleton, and that is the two parts. The Entry Clearance Officers Council readily accepted that what she meant in her written...
So where are you?
I'm terribly sorry, my Lord. That page is thrown. Middle of page 384.
What, but by reference to the side letters?
Yes.
C.
Yes.
Yes, okay, got it, yep.
So we've got, yes.
So how much do you want us to read?
The ECO's counsel readily accepted that what she meant in her written case by the proposition, the question of interpretation, down to intended. So was that the court's task is to discover from the words used in the rules what the Secretary of State must to be taken to have intended. And then the second point is further down there. The rules are her rules, but that intention is to be discerned objectively from the language used, not divined by reference to supposed policy considerations. So that's the thrust of the test that we've got.
Well, that's true up to a point, but like any other, call it legislation for these purposes, like any other legislative interpretation, it's not just the words, it's the words and the admissible context,
yes,
which will include where there are competing possible constructions, the consequences of one construction as against another. It's not just, we don't have to be more literal in interpreting the immigration rules than other kinds of legislation.
No,
and rather more relaxed.
No, and I don't say that you should,
right.
But what I'm highlighting there is that the thrust and the starting point is those rules. What does the language of the rules mean?
Yep.
Policy intention behind it is not irrelevant. Of course it's not.
Yep.
If we need, I mean, it's not in the authorities bundle, but the Supreme Court in Wang said something along those lines.
Yep.
But what we've got to look at first is what the language of the rule says.
Yes, of course.
And I suppose that the principal point here is if the language of the rule doesn't say what a party says it should say, it's not made good by, well, that wasn't the policy intention behind it. And that really is the issue to be determined in this case as to AAA. Now, there are, of course, for the purpose of today's date, two versions of AAA. The AAA that's relevant on the facts of this case that was in existence prior to April 2023, and then the new AAA, which came into force in April 2023. And of course,
how do you say that the new AAA is legally relevant in interpreting the version that we're concerned with?
It's not legally relevant to the interpretation of AAA that the court is being asked to look at, because the AAA that the court is being asked to look at can only mean what that says. What I submit the change in the rules assists with is, firstly, it is clear from the explanatory statement that came out with the statement of changes in March 2023 that the Secretary of State was clarifying that this was her intention all along.
But why is that admissible?
Pardon, my Lord?
Why is that admissible?
Well, it's admissible because it's a statement of changes that were published alongside the immigration rules.
Yes, but it's admissible to explain the new rules.
Yes.
But you were saying it's admissible to show that that was what she intended by the old rules.
No, forgive me, my Lord, that's not what I was meaning.
Oh, I see.
That the statement of changes in March 2023 that was accompanied by the explanatory statement changes the language of AAA.
Yes.
I submit that when from the appellant's perspective, that when we look at the AAA as old compared to the AAA as new, the two provisions do not, in our submission, say the same thing.
Well, suppose that's the case, how is that relevant? Which is my latest question.
So how it's relevant is, if they don't say the same thing, then what does that mean? What does the original AAA mean in that context?
But surely we've got to decide that anyway. The fact that the Secretary of State made subsequent legislation is, on a purist view, a strict view, but a strict, I would suggest, correct view, irrelevant in itself, and also because of what the explanatory notes say about it, because that's subsequent as well.
Well, if it's irrelevant, if it's irrelevant, it's not relevant to the interpretation of AAA, of the pre-April AAA. My point is a slightly more nuanced one, and it is that if you're with me on my submissions that AAA as was means what we say it was, then that's the start and end point.
Yeah.
The Secretary of State says it doesn't mean what the appellant says it means what we say it means, and that is whether it's what does not lawfully, otherwise not lawfully in the UK mean or not mean. There is little material we can point to, either of us, as to the interpretation of the language used. It's a matter for the court to determine that language to be used. What I can point to on behalf of the appellant is when the Secretary of State changed those rules, what she did in effect was, in our submission, to remove one word, and that's the word not.
Yes.
And that, in my submission, turns the meaning of that what AAA means 180 degrees on its head.
Yeah, I know that's what you say. I'm not actually stopping you developing the point. Quite apart from anything else, if we feel able to say something, whatever we say about the rules in their original form, it will help everyone to know what they mean in the new form, even if that's strictly speaking not the issue before us. I'm not asking not to make submissions about this, but I was really just following out my lady's point about how it fits in legally. At the moment, I still haven't quite understood it, but anyway, yes. Yes. But my lord makes the point that it's difficult to look at in the abstract. Well, at the right stage, it may be now or whenever you're going to do it, let's look at it properly. My lady and I wanted just to give you the opportunity to explain beforehand why you said it was relevant. And I think We've heard a certain amount. If you want to say any more later, do.
So I can address it now, and it might come in through a different angle in due course. But to address it now, legally, the new AAA does not inform what the old AAA means or said. The best I can point to, though, and it's a point that I develop, is to if the Secretary of State is right as to this is what AAA always meant, what difference is there in the change of language?
But all that would mean is that she made an unnecessary change.
Yes.
Well,
so what?
Yes, it might also mean, and again, this may be more a question for the Secretary of State, if the Secretary of State's arguments were right in relation to the old version, then that leads to certain questions about the effect of the new version.
Yes.
Which is really the obverse of what
yes,
of your argument, but I think that's something that it may be helpful for both parties to address.
Right. Well, we now know why you say this is an exercise worth doing, but do it at whatever stage you were going to do it, either now or later.
My Lord, yes. I mean, on final point on the new rule is we accept that the new rule says, and otherwise were lawfully resident, and that makes sense.
Okay.
So, without further ado, if we go to the language of AAA itself, we submit, and you've seen how I...
Sorry, can I always like to look at these things in context. AAA, I don't know, I'm looking at the authorities bundle here to see it in context. I'm on page 176 of that. AAA forms part of subparagraph 2, B2, doesn't it?
Yes.
And there was just one query I had. I don't think it's a live issue in this appeal, but I'm really just trying to make sure I understand it, because I think the point was raised below at some stage. The first paragraph, or the first set of words within paragraph 2, Roman 2, is talking about durable partners of relevant sponsors or spouses of relevant sponsors. And when you work through, if you find the definition of relevant sponsor, my reading of it, and I haven't gone into this in detail, is that it all appears to relate to the concept of joining family members. And I think this point was raised at some point earlier in these proceedings, and indeed possibly in an earlier Upper Tribunal case. It seems to be, if it's right, that might suggest that the entirety of paragraph 2, including AAA, is or may be limited to a situation which we're not dealing with here because the appellant was in the UK at all relevant times. I know it's not a live issue, but I'm just, I can't avoid reading the context.
Raising that, my lady, I'm sorry to interrupt. That is a point that I will address in
Oh,
my
you will?
submissions. But
Okay.
in short, that is the Secretary of State's position. B22 does relate to joining family members, but for the purposes of this appeal, we don't say anything necessarily turns on
Right.
that in terms of the outcome for this applicant.
Okay,
But
well,
I can take you through that in more
I'm glad
detail.
I've raised that, because it wasn't terribly obvious from your skeleton, and
Going back over my skeleton,
and then
I agree with
it's
that, and I
something
apologise.
that Mr. Wilding may need to address if it's something you're relying on.
Indeed. Is it best if I come to that in my submissions? Or
Well, then Mr. Wilding will need to have a chance to
we'll have a
respond.
chance to reply. Oh, well,
Thank you.
with that, but thank you. But in short, yes, we don't say that anything turns in terms of
If
the
you're
outcome.
if you're prepared to deal with it, Mr. Wilding, unless you had a riff prepared on it now, you may want to wait, see what Ms. Jackson says and deal with it in reply.
I will take the opportunity to see what my learned friend says, my
Okay.
Lord. In my submission, nothing greatly turns on it for the purpose of this case and this reason alone. This is an application that's made under Appendix EU, not Appendix EUFP. Appendix EUFP is the application for a family permit for someone to...
Well, I happen
Sorry,
to know,
can you say that a bit more slowly?
Yes, so you don't have the material before you in terms of Appendix EUFP, but Appendix EUFP is the immigration rules for someone to apply for a family permit from abroad to come to the UK.
Well, I happen to know about that because I did a case about it.
Yes.
Called Rexhaj, but
I'm familiar with Rexhaj.
yes, but I can't. Why is that got anything to do with what we're here?
Well, no, but in terms of the contextual question about is B2 only for circumstances where someone is applying to join? The context of the question is there's an application to join, and if the appellant is here, he's not joining anyone.
Okay, but sorry, you're saying we're not. This isn't an application made under the EUFP appendix. This is an application made under
Appendix EU.
Appendix EU, but we're looking at Appendix EU, so
Yes.
you may still need to deal with the
And
words.
I can deal with it,
Okay.
my lady, yes. The Secretary of State's hypothetical person that is not someone in the appellant's situation, but someone who is lawfully in the UK, would be in the exact same boat as the appellant in terms of they're still applying to remain, not to join.
I think you're either going to have to say more or less. I mean, I incline to think, can we just not leave it?
Yes.
See, Ms. Jackson, whose clients' rules they are,
Yes.
may give us a clear overview. And if you think she's got it wrong, you can tell us at that point.
I'm grateful.
Okay.
So the context in terms of the immigration rules and the durable partner definition is found in the box, durable partner, of which my lady says we've got AAA as a component part. AAA, though, is the component part of B Roman 2. And B Roman 2 tells us that where the person is applying, and in our case it's as the spouse, and does not hold a document of which B1 above applies. Now that document is specifically an EEA document, so a document issued by the Secretary of State under the EEA regulations.
So what would be the precise relevant document? Would it be a residence card?
Yes,
Yeah, under those regulations.
under those regulations, yes. And then the subcategories in B Roman 2, so we don't have a document of which B Roman 1 above applies. The date of application is after the specified date. Well, yes, it is. And the person BB, AAA, and this is where this case turns. Though, and I'll come back to it obviously for the purpose of my developed submission, but underneath that you've got triple B and triple C, which apply in very different situations to the circumstances before the court here. But perhaps importantly, after triple C, and this goes over onto page 177, the Secretary of State has the additional consideration. The Secretary of State is satisfied by evidence provided that the partnership was formed and was durable before.
Sorry, where are you reading from?
Page 177, at the top of the box.
Oh, sorry. Yes, I see. The bit that goes to the left-hand margin.
Yeah.
That's the critical words. Those are the critical words, aren't they, that tie this to being a durable partnership before the specified date.
Yes, before
So,
31 December 2020, yes.
Yeah.
So that's the context in which the rule is considered, and the facts obviously are injected into that. So
Just what's the syntax of that? That
qualifies the whole of 2, doesn't it? Roman 2.
yes.
And my reading of it.
Yes, yes. So that's not just restricted to triple C. Some versions of the rules, it's all condensed in, but my submission is that that is relevant to AAA, a triple B, or a triple C. It all falls within the context of B2.
How does it just work as a matter of language?
I
Is there a conjunction anywhere?
The and where before double A.
I mean, certainly
Well, and where double A is fine,
yeah.
and the person does or doesn't satisfy the requirements of triple A to triple C.
Or it may be before the comma before and where.
I mean, is it a further condition of BB? Shouldn't there be an and somewhere?
My reading of it has always been, my lord, that it's a component part of BB, not that it's restricted just to a triple C situation.
No, that I accept, but I'm sorry, I'm just being pedantic. I think that must be what's intended, but I just want to understand where the language says so.
Can I just... do you mean a component part of BB? I think it's a component part of the whole of 2. Certainly the margin location would suggest that, and that to me makes more sense.
My lady, yes, but I don't think whether it's a component part of BB or the whole of 2 probably matters not, because you've got to meet
well,
one of the
it may
conditions.
matter to try and understand.
Yes, if my lady is right, so I don't have a debate with her, the way it should have been done would be to have an and after specified date, and then a CC, because it would be a third and where, after little Roman 2, and where AA, BB, CC. Yes?
I think it's the...
Sorry, if it were just this is the it's interpretation. So if we go to B2, so we've got the whole section there, and the last 3 lines it says, and does not hold a document of the type to which subparagraph B1 above applies, comma, and where, and then we get AA and BB, and then we finish BB with a comma, we then have the Secretary of State is satisfied by evidence. So we've got quite a long clause, I think. Yes.
But how?
Can I suggest one? If you put square brackets just for a moment around the whole of and where AA and BB, you could make 2 read sense by saying that if you don't hold the document, you have to be satisfied, going straight to the closing words, by evidence. But then in addition, you have to satisfy AA and BB. In other words, the closing words are actually the operative part of, in one sense, the operative part of 2.
I think that's essentially what the Secretary of State's trying to do with commas rather than closed brackets.
I didn't mean real brackets. I meant just in terms of trying to read it to make sense.
As I say,
Still
that's
think
how.
there's a missing and somewhere, but
I think it is because.
okay. Well, I think I'm wrong here. My lord and my lady can make sense of it. I just haven't tried hard enough.
I'm grateful. I mean, obviously the Secretary of State's position is we've clarified the wording since, but.
I don't think we've clarified it in this respect, but.
Exactly.
But do you say that that closing clause, starting the Secretary of State is satisfied, applies to the whole of 2, Roman 2?
We do, yes.
Yeah, thank you.
Thank you.
I think I'm just going to get off my chest once. The Home Office should be thoroughly ashamed of this drafting. It's almost incomprehensible, and it's particularly upsetting where the courts have made many observations about the previous rules, not previous, about the earlier versions of the rules. The Law Commission did an excellent job giving some guidance as to how to construct rules that people can understand, which just seems to be wholly ignored in the drafting of this. And it's a great shame. I'm not trying to give you a hard time, and frankly, I'm only saying it. I can't bear not to say it. We'll just have to make the best of it. But There we are. I'll try not to say it again.
I'll pass that back, and the Secretary of State does acknowledge that the wording is complex and is grateful for the court's time in trying to make sense of it.
Yeah. It's not just the particular problem we have about AAA, it's just making sense of the whole, how it all fits together with all these AAAs, BBBs, no proper punctuation, or the punctuation depending on the spacing. It's not how you ought to do things. Okay.
I'm grateful. That will be heard.
Zip my lip. I'll try to. Right.
And it is the change that in 2 lines before the end of AAA, in the old version, the words "and they did not otherwise have" are replaced by "and they otherwise had." That's the material change.
Yes. I don't wish to pour a small can of petrol on the drafting of the immigration rules, but just because I made the submission and I've noticed that you can see on the current version of the rules how it is presented slightly differently in terms of to the observer rather than to the language used.
Do we have the current version?
You do, yes. Page 48 of the pages 47 to 48 of the authorities bundle. Obviously, the definition durable partner starts on 46, but the relevant component parts we're looking at is 47 and 48. Now, unfortunately, when one has the current version of the rules are found in the gov.uk website rather than archived versions which are presented in the boxes we've just been looking at. So it's far more linear and makes it that little bit harder to see.
So so this...
It's even worse.
It's much worse. Is that really the case, Ms. Jackson, that there isn't a printed version of this?
We don't have one in the bundle. I'll see if I can take instructions to see if we can get
Because we all...
version.
If you look...
Apologies. Thank you.
I quite understand everything has to be on the internet, and that's where most people will access it. But I'd always assumed there was nevertheless a printed hard copy somewhere, which was the authoritative version. And on points like spacing and punctuation, which oughtn't matter, but clearly do matter here, you would be able to look at the printed version. Yeah. Is that what you've just been handed something?
I've just been handed a printed version.
Is that more like the old version?
It is like the old. So if you just allow me to move back for 1 second. So is it the case that the current version?
I think more sensible would be to get, I suspect we're going to go over lunch, could we have the authoritative version in the sense where the layout is not an internet layout, but is a PDF layout, realistically?
I'm sure we can get a copy of that.
Yes.
Thank you.
Old, new, or both?
Sorry?
Old, new, or both?
My lord is saying old, new, or both, but I think we have, what we have for the old version is
Indeed.
the printed, what I'm calling PDF version.
Yes.
That's what a paper, if there is a paper version somewhere, this is what it will look like. Whereas the new one, we've got in a version that's just been printed offline and is much more difficult to follow for those layout reasons.
Yes, sorry.
When you find the authoritative version, can we have it in both soft and, if possible, hard copy?
I'm sure we can arrange that.
Yes.
I'm also not sure if this is how exactly it reads if you're viewing it online. Obviously, we've printed it out, but,
Yes.
but I'll get...
I haven't looked at the world being what it is, one's always only ever looking at archive versions online because the rules have always changed by the time they get to this court. But you can normally see something that I think is right. You can, as it were, click for a PDF version, which then looks like the old version that we have in this bundle. And that's always what I do when I can.
Yeah. Well, I've just seen that copy exists, so I'll do my best to get hard copies and soft copies to court.
Thank you.
Thank you.
Right. Well, I'm sorry, that's wasted a bit of time, but I think actually productively, Mr. Wilding, you were going to do your best I think, to show the differences in the new version.
Yes, just really.
Is that possible to do on this version? You think it is?
It is, yes,
Yep,
because
okay.
thankfully, in terms of the relevance of the new version, we're only looking at that narrow reformulation, which you can see at the bottom of page 47 that strays into the top of 48.
So that's the only relevant change, is it?
For the purposes of my submissions, yes. I mean, the rules are an ever-changing situation and set of rules, of course. But in terms of the purpose of this appeal, we can see at the bottom of 47 that what was rejigged and inserted, so to speak, are those 2 bullet points you can see. The reason why they were not so resonant is, and they otherwise had a lawful basis of stay in the UK. But the second point I just wanted to...
Hang on 1 second. Yeah.
And then the second point, just to highlight, and this really highlights and brings home, so to speak, the point that I made earlier when talking about how the rules present themselves. Middle of page 48, you can see CCC end after, well, I think agreed end after the specified date, comma, and then it says the Secretary of State is satisfied by evidence. You can see there's no change in the indentation. Now, from my understanding, that's how it has always presented itself on the most current version of the rules on the gov.uk website. So
Yes,
unlike...
but there's no indentation in any part of that.
No, because it just reads as this...
Well, that's, I'm afraid, it was that I was more interested in
Yes.
at this stage than in the 2 bullet points.
So if obviously...
But we can't... Your point doesn't go anywhere until
no.
we see what it looks like in the printed version.
Yes, quite. But I think just to answer that, possibly what one point is more possibly a housekeeping point than a point that we're looking at per se. But the only version through the gov.uk immigration rules website that I can see that you can obtain on PDF is for archived versions. The current version of the rules does not appear, unless I've missed something, on the various drop-downs as provide me the PDF of the immigration rules. But that's just an observation. If I've missed something, I've missed something.
Well, that's astonishing. So if you want to know what the current rules are, you get a version where all the indentation and so on has been stripped out.
Depending on what that particular rule says.
Yeah, sorry, I'm being...
No.
I'm being instructed that apparently because it's on a government.gov.uk website, the formatting is controlled, so it's not possible to put in the indentation.
But that's monstrous.
It's the explanation rather than the justification.
Well, okay, the rest was just me having a huff. But if that is really correct, that is something that really does need to be tackled, and we might even, we might ask for a note about it, say something about it in our judgment, because in order to understand these rules, you have got to have them presented with the layouts and the indentations. It shouldn't be so, but it clearly is so. That's the way they're written. You can't understand them unless you see that. And if the only version available to the public is one which has that stripped out, that is, I've been too pompous about it, contrary to the rule of law. You've got to see the statute as it is. It's got to be available to the public. Now, I suspect there is a printed version because the statement of changes has to be laid before Parliament, and unless Parliament has changed a lot recently, that does still mean a printed statement of changes. But if that's not available on the gov.uk website, which is where the public will go to find the rules, that's no use. I'm not expecting you to have answers to all these points, Ms. Jackson, and it's directed, I hope not in a bad-tempered way, but to those behind you. But I'm sure they get the point, and even if they don't, I'm sure you will. I'm sure you won't have to, but you'll explain it. Right, I don't want to spend any more time on this, but it is actually more important than anything that's occurred so far in terms of otherwise it's just us complaining that these are badly drafted, which we all know. But if you can't actually find them in the authoritative version, then we are in trouble.
Well, I'm
Sorry,
going-
that's...
I will take it away. And,
Yeah, it may be, and
it's
it's...
best that we put in.
I think clearly we won't say
anything
anything about it without having given you an opportunity to write a short note on the point, and we will tell you at the end of the hearing whether we want that, but we might, because it's important enough to say something about.
I'm grateful. Well,
Thank you.
as I said, I'll take it away and
Right.
see if I can get you.
Mr. Wilding, I'm sorry you're being interrupted a lot, but I think it'll gradually settle down.
My Lord, I'm grateful. And again, there is just on something that the court observed that I would just come back on in terms of statements of changes. The statements of changes that are published are just that, what changes have been made.
That's true.
They're not the entire set of immigration rules that are currently in force.
I know that, and I know that, but at least the changed passage is set out in old-fashioned print, or it used to be anyway. It must be. But I agree, you can't work from that because you then have to work back through previous versions. But anyway, yes. Keep going with the substance.
My Lord, yes, thank you. So we go to the relevant rule in question, which is the old rule that we've been just looking at, page 176. And what does AAA say? Now, in my submission, and it's been a consistent submission of that the appellant's been making, there are three component parts to the AAA test. One, the person was not resident in the UK as the durable partner of a relevant EEA citizen on a basis which met the entry for family member of a relevant EEA citizen in this table. Now, we submit that we were so resident. Resident does not have a separate defined term. We say we do meet the entry of family member of a relevant EEA citizen. That section of the definitions can be found at pages 182 and 183, which tells us that they are for the relevant period or at the relevant time, but for the purpose of this appeal, we're talking about for the relevant period.
Sorry, which definition precisely?
Family member of relevant EEA citizen.
When it says in this table, one of the oddities of Annex 1 is it calls itself a table.
Yeah.
It's actually an annex, but that's what it means in this annex. Yeah.
It must mean that.
I'm sure, but I just want to be clear.
It must mean that.
So you say we were a family,
Yeah.
a family member of a relevant.
They are for the relevant period. So present tense for the relevant period. The spouse or civil partner of a relevant EEA citizen, which we were, of course, because when we applied, we had got married. We are Roman 1. We don't meet because the marriage was contracted before the specified date, which wasn't. The marriage was contracted after the specified date, 31 December 2020. But in my submission, we are a 2, or the applicant was the durable partner of the relevant EEA citizen before the specified date, the definition of durable partner in this table being met before that date rather than at the date of application, and the partnership remained durable at the specified date. And that, in my submission...
Sorry, where are you reading from?
That's Roman, that's A Roman 2.
On page 182.
183. It's,
No, that's not the right definition, is it? Your 183
terribly
is family
sorry, yeah.
member who retain the right of
I'm
residence.
terribly sorry, my lady. It's 181. 183.
So-
Terribly sorry.
So, looking at 181 to 182, you say in A, yes, we are now the spouse.
Yeah.
And we fall within A2.
Yes.
Do you also say that you fall within B?
We don't need to fall within B
Yeah. So
because we were married by the time we applied.
yeah. So you can focus on A2.
But if we hadn't have got married, then B would apply. You're applying as the durable partner. The partnership was formed and was durable before the specified date, and the partnership remains durable at the date of application. So the definition encompasses anyone that is in or was in a durable relationship prior to 31/12/20, remained in that relationship through 31/12/20 up until the date of application. Whether you're an A or a B is determined by whether you've got married or not.
Of course. So we take that back to page 176.
So just before we leave 181, this may be relevant to what Ms. Jackson's going to address us on later, but I noticed that the definition of a family member starts a person who does not meet the definition of joining family member, which is somewhere else, and who has satisfied the Secretary of State that they are in a relationship with the various alternative characteristics. Ms. Jackson's nodding.
Sorry. Yes, that is.
Yes, well, you'll deal with it. You'll
They're
deal with it later.
alternatives.
But I just noticed that as we were passing. So, can we now go back to AAA?
We can, my lord, yes. So that in my submission, we satisfy the first limb.
So what you're calling the first limb
is
from where to where? Was not resident
on a basis which met the definition of family member of a relevant EU citizen.
This may be the use of language. You said we satisfy the first limb. We just said we don't, because the first limb is in the negative.
Oh, sorry. Yeah. We were not we were not.
You say we were actually resident, so we don't fall within those.
So
words.
yes, we. What I mean by our submission is we were not. Yes, we were not. We meet the we meet the qualifying definition of family member of relevant citizen in this table. The person was not resident as someone who met that definition, so we don't meet that because it's a not. The second, this is where the unless clause comes in, and this is the second part of the three-stage process, and we can see in the middle of the box of AAA, unless the reason why they were not so resident is that they did not hold a relevant document as the durable partner of a relevant EA citizen for that period. So we're out. The unless clause brings us back in.
What do you say about the words "the reason why"?
My understanding of unless the reason why, and that the reason why is why they were not resident, because that's the only way to make sense of what that reason is referring to. Because what follows after the bit about were not resident, it says on a basis which met the definition, or as the case may be, the durable partner of a qualifying British citizen, in either case, any time before the specified date, unless the reason why, in the former case, which is the durable partner of a relevant EEA citizen, they were not so resident is that they did not hold a relevant document. So the reason why, in my submission, must refer back to the reason why they were not so resident. And so
You just said they are resident.
we say we were, well, the language of the rule says you were not resident for this on this basis, unless the reason why you weren't resident is you didn't have a document confirming it. And now, obviously, if you had a document confirming it, you're not in B Roman 2 territory because you're in B Roman 1. You've got a relevant document. So this B Roman 2 is all about situations where someone is in a relationship durable relationship prior to 31/12/20. It runs through the specified date, i.e. it hasn't ended, continues to run up until the time you make your application. You either got married or you remain in a durable relationship, but you don't have a document of a type confirming that you are someone who is in a relationship with a relevant EEA citizen. And that, in my submission, is the only sensible reading of this provision, because even in the Secretary of State's submission as to why we're wrong on the third question, which I know we haven't come to yet, is, well, what this is really designed for is to capture someone that is lawfully here, but lawfully here as a student or on a worker visa or something like that. But the only way that hypothetical works, in the same way that our submissions work, is if the first and second question are really all about, do you satisfy this definition of relevant, partner of a relevant, family member of a relevant EA citizen, and the only reason that you didn't qualify on that is because you didn't have that relevant document. Now, it's a really strained way of drafting, and I'm not going to go over the drafting of the definitions, but realistically, that must be the only understandable reason for that. Otherwise, the open question is, who does this category apply to? If it doesn't apply to anyone.
Suppose that all the facts of your client's case were the same, except that the basis of his being here in 2020 was that he was here on a student visa. So he wasn't an illegal entrant to the UK. Would he come within this provision?
Up to the final point, and I think that's the Secretary of State's case, that the Secretary of State says because he would be lawfully here, that's the type of situation that this rule caters for. But in terms of what the difference is between someone without status and with status is only found in that final clause that we haven't come on to.
Yes, but
tell me if I'm wrong, but it seems to me, on your case, your client is entitled to be treated as durable partner within this annex because he had no lawful basis of staying in the UK. But if he had had a lawful basis, he'd be worse off.
He wouldn't be able to qualify under this provision, no.
Yeah. But that seems very odd to me.
I addressed that point, my lord, in my submissions on the third clause. My
perhaps you better come to the third clause.
And the third clause is, and they did not otherwise have a lawful basis.
Yes, I know, but you were doing this very systematically. But actually, the meat of this case is about the third
absolutely,
clause.
my lord. Yes.
So I'm just suggesting we get to that.
Yes,
now.
absolutely.
Yep.
So, and this is the point that the Upper Tribunal made in the reported decision of Hanny, and the Secretary of State makes in submissions, that it creates an absurdity.
Yes.
And my submission is that, firstly, the correct approach is to read the rules, consider what the language of the rules says, and then consider what follows after that.
Yeah.
Secondly, there's nothing inherently absurd about a category in the immigration rules for someone that was not otherwise lawfully in the UK. So we've seen that, we have that in other parts of the immigration rules, Appendix Private Life, for example, the exceptions to Appendix FM, for example, and someone that is in the hypothetical situation of being lawfully present as of 31/12/20, who happens to be in a relationship with an EEA national, can make an application under Appendix FM. So that there isn't an absurdity in that there's a category of person that cannot rely on their relationship with their partner.
But that's not the absurdity which my Lord is putting to you. As I understand it, the absurdity is that someone who is lawfully here is worse off on your interpretation of AAA than someone who isn't lawfully here. Is that?
Yeah.
Yes. That you are not addressing that absurdity.
Well, my submission as to the absurdity is worse off in the sense that they can't apply under this provision of the immigration rules. Yes, they wouldn't qualify under this part of the immigration rules. I accept that. What the consequence of that, though, is that an absurdity, a real one, so to speak. Now, in my submission, it's not, and the reason for that is because that category of person wouldn't be prevented from applying for leave to remain on the basis of their relationship with their partner. They wouldn't be able to rely on this provision. I accept that, but that does not inherently, in my submission, create an absurdity.
This is quite a privileged route, isn't it? In the sense that if you fall within this, effectively you demonstrate your durable partnership, and then it's pretty much a tick to get at least limited leave to remain.
Yes.
Obviously, we're not being taken to the details of the other routes you mentioned, but are they quite as straightforward as that?
There are different considerations, including how much someone earns and so forth. Yes.
Absolutely.
So there are differences. I accept that.
Whereas on this route, you wouldn't need to, as I understand it, demonstrate, for example, financial independence.
No, not to the specified income level. No. But
the purpose of this scheme, if it's the right word, is to make certain people present in the UK privileged on the basis of their status on Brexit Day, 31st December 2020. It's a sort of one-off, that's the specified date. Why should Secretary of State, the drafter of the rules, be intending to create a privileged category limited to people who were here unlawfully? Seems very odd to me.
My case does not point to, well, this is what the Secretary of State must have intended to do. I certainly can't point to any material to suggest that, and the Secretary of State says it was never our intention to. My submission is, what does the language of the rule say and mean? And it would be wrong in my submission to interpret the words and language used within the immigration rules framework, squarely focusing on, well, this is surely not what the Secretary of State intended, if my submission is right, that the only rational meaning of the words used is that it caters for someone who was otherwise not lawfully in the UK. So it comes down to that final clause. And if that final clause means what we say submit it means, then the fact that the Secretary of State didn't intend to do that is my submission is neither here nor there, because where we get to is, if that's what the rule says and means, no amount of analysis or consideration as to, well, this is
when you really, so to be fair, this is a perfectly understandable submission. You basically take the absurdity on the chin. You say, if it's sufficiently clear, if the words are sufficiently clear and they produce an absurd result, tough, that occasionally happens, and the government has to go away and legislate again, which actually is easier here because it's only immigration rules.
Yes.
She can change them pretty well at will. So, and that, it comes down to that. You say, you accept, may not like the word absurdity, but you accept the point that is being made about it being a surprising outcome in this respect, possibly in others as well. But you say, that's what the words mean.
Yes.
And it's absolutely clear.
Yes. And this, my lord, is where we get to the relevance or otherwise. The court might not consider it all that relevant if you're not persuaded at all that the rules can't be read in the way that we advance. But this is where the relevance or interest or assistance is gathered from the amended rule.
Well, fine, But is that really all you have to say? Suppose that other rules had never been made. That's your straightforward submission on the meaning of AAA.
Yes.
And that's your answer. I mean, I don't just slow you down, so I don't want to speed you up. That maybe you may. Do you want to go to Hani and the other cases, or would you say
I've got short submissions on them to deal with the points that are made in them, but the end point that
they'd all come back to the same?
It all came back to the same point. That is.
Well, it's entirely up to you. In a sense, I think it would be helpful just to make all your submissions on the old rules, which including any authorities about the old rules, if you want us to look at those, before you then come to the self-contained question of the relevance of the new rules.
Yes,
let's keep it clear.
That's exactly the structure I intend to.
So where are you going now in that case?
So where I'm going now is I've dealt with the perceived absurdity. We say that looking at the language, they did not otherwise have a lawful basis of stay means what it says it means. There's just a couple of submissions I make in respect of under three particular headings, because the Secretary of State deals with this in her skeleton argument: the withdrawal agreement, EEA regulations, Chelik, and then Hani. In terms of the withdrawal agreement and EEA regulations, you have a lot in writing from the Secretary of State, but we say that really doesn't answer or address the central question. The point being is that in the pre-Appendix EU scheme, an application made under the 2016 regulations as a durable partner, under Regulation 8.5 of those regulations, could be made whether someone was lawfully or unlawfully here. So the category of person hasn't changed, it's just been narrowed. As we know from Chelik, in terms of the withdrawal agreement and in terms of how it interacts with Appendix EU.
So it was under the pre-Brexit scheme, an application could be made by someone unlawfully here.
Yes.
Under Reg 8.5.
Under Regulation 8.5.
This is the 2016 reg.
Correct, yes.
And you're saying under the withdrawal agreement scheme that remains so, but the category has been narrowed. Is that right?
Yes. And all we glean from the withdrawal agreement is no matter who qualifies under AAA, it is in essence outside the protections of the withdrawal agreement. Or to rephrase it, the rules are more generous than the withdrawal agreement's captures.
So the whole of AAA is we can't glean anything from the withdrawal agreement.
Correct.
Effectively in relation to AAA.
Yes.
Okay, I get the point.
In relation to Chelik, the Secretary of State relies on Chelik, but the definition or otherwise of AAA was not before the courts in Chelik. You've got two paragraphs that purportedly deal with. I wasn't here in Chelik, obviously. I can't speak to the submissions that were made, but reading Chelik does not give. I know my lone friend was, but reading Chelik does not give the impression that there was any particular argument about.
To be fair, I don't think the Secretary of State says so. I think he just, the furthest she goes and the furthest the Upper Tribunal goes is, if I can put it this way, mood music. It would be surprising if, but I don't think anyone is suggesting that the point is actually tackled.
Yes, I'm grateful. And that therefore brings me to Hani, and there's only a couple of short submissions on Hani because you've got the thrust of my submissions on the language. I mean, the one obvious observation, and it doesn't take me very far, but it's rather unsatisfactory. A decision of the Upper Tribunal is reported and there's no argument on the point. But it doesn't take me.
I can see why you can't resist making the point. It doesn't take you very. The fact is, it was very carefully looked at. You say, nevertheless, the wrong answer reached. But if we rely on Hani, it'll be because we're persuaded by the Upper Tribunal's reasoning, not because we're bound by it.
No, quite
we
so.
aren't.
Yes, quite so.
So.
But I think the important point that Hani develops is the absurdity point.
Yes.
And my submission on that is the Upper Tribunal, in my submission, places an over-reliance on that absurdity point as to, well, this is possibly what the Secretary of State could have meant, in order to interpret what the ordinary language of the rule says. What Hanny doesn't do is to say, this is what the rule means in ordinary language. It could mean X, Y, or Z. It only means X, and so forth. Instead, the reasoning of the tribunal in Hanny incorporates the policy intention to look at the meaning of the language. And in my submission, that's an impermissible approach. You have my submissions on absurdity.
Yeah, that's very helpful.
So what I submit is, on a careful structuring of AAA, which we submit all along has been this three-stage questioning process, that we get back to, and they did not otherwise have a lawful basis of stay in the UK, and that falls in favour of our submissions on what that means, i.e. that is someone who is not lawfully in the UK. Now, unless there's anything further from your lordship's ladyship as to my submissions, I'm just going to deal now with the new rule point.
Yes.
Now, the new rule is helpful in our submission on assisting our case. This is because, firstly, it agrees with us that it's a three-stage question, because we've got, for the first time, interjected the 2 bullet points. So there's a qualifier at the start of AAA and then 2 bullet points. And they are sequential, something and something and something. Secondly, the second bullet point in the new rule tells us, and has been amended, they otherwise had a lawful basis of stay in the UK for that period. Now, just taking a step back, the Secretary of State says, well, we're not changing anything, this is just clarifying the situation. The only word that has been deleted from AAA is not. That, in my submission, changes the fundamental meaning of that provision of the rule, that clause. To put it another way, they otherwise had a lawful basis of stay in the UK for that period cannot, in my submission, mean the same as they did not otherwise have a lawful basis of stay in the UK for that period. That in terms of grammar and understanding of language, does not, in my submission, work. And that is the only change to the rule. The Secretary of State says, well, it removed a double negative, but removing only one not, in my respectful submission, doesn't remove a double negative. It converts the meaning of the entire phrase. And in my submission, therefore, where we're left is post-April 2023 change. Well, the changes are in March 2023, but post-April 2023, when the provisions came into force, you have a clear rule that says, and otherwise had a lawful basis of stay. In the pre-April 2023 version of the rules, the meaning was different, not just different, but significantly different, 180 degrees different in my submission. And that is my submission. That's my case on AAA. Now, of course, the final point I made on AAA, of course, is the Secretary of State in her skeleton argument accepts it's arguable that it can be read in either way. She doesn't say that our reading of it is manifestly wrong in terms of grammar. What she says is it wasn't the policy intention. It can arguably be read in both ways, but prefer our version of the interpretation.
Just on that, if something can be read in more than one way, you could say it's ambiguous, that would suggest that the wording is not clear. Whereas, in answer to questions from my lord, you were effectively saying the reason we should find in your favour is because the wording is clear.
Yes. I don't submit there's ambiguity.
Yes. But how does it help you that the Secretary of State says that it's ambiguous? That's a very common situation. A piece of legislation is ambiguous, and then in deciding which meaning to prefer, you look at which makes most sense. That's all she's saying, isn't it? Why is that helpful to you?
It's helpful to me in one simple short point. It's not helpful to me to take me a long way down the road, But it's helpful to me in the sense that what the Secretary of State is not saying is this is a completely impermissible way of understanding what it means.
All right, but we have got to decide a right answer.
Yes.
This isn't like a discretionary decision where, if it could be argued either way, so a tribunal can argue it either way. There's a right construction.
No, we're not saying it can be defined however anyone says it.
Yeah, no, quite. I'm only making that point. I'm not quite sure what's left, though.
No.
Okay.
I mean, it's just a simple point to deal with that.
Yes,
so those are my submissions on AAA. Unless my Lordship, you have anything else on the immigration.
Thank you very much, Mr. Welling. So the other ground.
The other ground, it's shorter. It's not unimportant for the purpose of this appellant, and there is a point of principle found within it, but perhaps arises less. And that is the way in which the FTT considered the evidence before it as to the nature and degree of the durable relationship at the material time.
Yes.
Now, the Secretary of State says broadly, well, the tribunal came to decision, made reasons, gave its reasons, and that it can properly be understood. The short point we make is, if we just go to Judge Clark Stewart's decision, and it's dealt with in one paragraph, paragraph 15 of that decision.
Yes.
At the specified date, appellant...
So, can you give us a page number, please?
93 in the core bundle.
I'm glad it mirrors up to the PDF pagination then. We can say specified date, appellant sponsor, been in a relationship since November 19, only living together a year later, no more than a month of cohabitation, and that is, it is said, is insufficient to find at the date that they were in a durable relationship on the 31st of December 2020. My submission point on that is that it firstly ignores the actual evidence that the tribunal had before it. Factually, in terms of they got together in 2019, started living together a year later, had been cohabiting for 2 months by the time the specified date ticked by, factually it is correct. Chronologically it's correct. But the immigration rules say 2 years cohabitation, or unless there's better evidence to suggest that the relationship is a durable one. Now, this is where the relevance of the supplementary bundle comes in.
Is a durable one, or was a durable one on the critical date?
Well, in my submission, you can't compartmentalise it to say, and on the facts of this case, I say it doesn't matter whichever way you look at it, because they were in our submission a durable relationship as of 31/12/20.
Well, that surely, my lord is right. That is the key question. Your point is your point is not to say that's irrelevant, but to say in judging that question, effectively, the fact they got married 2 months later is highly relevant in judging whether at the relevant date the relationship was already durable.
Yes, the quality of the relationship.
Exactly. And I think Ms. Jackson doesn't dispute that, but she says that the judge didn't make that error.
Well, you would say that the judge did make an error in referring to the required 2 years of living together.
Yes, the judge has not...
Because you might say, well, the judge was proceeding on the basis that in all cases there has to be 2 years of cohabitation.
The judge didn't immediately... It's not immediately obvious that the judge had in mind 2 years is the starting point, but what other evidence is there? And what we have, and I'm not going to take you through chapter and verse.
So can I just be clear about this? I hadn't understood you to be saying that the judge had misdirected herself on the basis of that phrase. I appreciate if that phrase was taken in isolation, it would look like a misdirection. But looking at the whole paragraph, of calling it the required, she really means the default 2 years, but the paragraph is intended to say that there's nothing, the exception to the default 2 years doesn't apply.
Well, how I characterise it is, we've only got paragraph 15 to go by as to what the reasons are for not finding a durable relationship.
Yes.
My submission is, by reading that, we don't see any particular account taken of the marriage shortly thereafter, the evidence that this was a relationship that had developed over the course of a year and a bit, that the fact they had only been living together for 2 months in a particular case on a different set of facts might be a concern, but the evidence before the tribunal was shortly after moving in together, the appellant proposed to his wife.
Yes.
That all taken into account into the melting pot, as it were, applying Regulation 9, circumstances.
But not just, I thought your bull point, as I understood it, was that they had in fact gone to the registry office, or they had an appointment. Not quite clear what that means. You'll perhaps help us on this. They had an appointment on, believe it or not, Christmas Eve. And then COVID intervened in some way. It's not clear whether it's been said that they were going to get married on Christmas Eve, or that they, which I think is still the procedure, you have to go to the registry office beforehand and go through various formalities. But that pre-meeting was going to happen on the 24th. But either way, in a sense, it'd be even stronger if they were going to get married then. But either way, your point is they had actually taken the first steps to getting married.
Yes.
And that shows it was durable.
Yes.
Am I got that right?
Yes, my lord. It's that body of evidence that was before the tribunal that, in my submission, was not properly taken into account when considering the durability of the relationship.
And some of that evidence, because I think your round of appeal didn't look at the evidence in the round, but some of that evidence, 24th of December 2020, obviously predates the specified dates.
Yes.
So your point is not limited to the relevance of evidence after the specified.
No. But and the only of the Secretary of State put it has included 3 unreported decisions in the bundle for which she'll make submissions, I'm sure. But in the unreported decision of Shahzad, the tribunal do give some consideration to this question of considering the evidence as to going to the durability of the relationship at the specific time. And in my submission gave short shrift to, in that case, what the Secretary of State was seeking to say, and that is attacking the status or the genuineness of that relationship at that particular time. And the reason that the tribunal gave for that is, look, we've got to take into account all the relevant evidence and all that relevant evidence. That
we'll have to hear Ms. Jackson. But I understood her submission to be, I'm not saying the fact they got married afterwards is irrelevant. I'm only saying it's not determinative. And it was for the judge to decide what relevance to give to it. It's clear the judge is quite short, 15, but what's wrong with being short? It's clear, reading the thing as a whole, the judge did take it into account, but she didn't think it was good enough. End of story, factual question for the judge.
In my submission, it's the failure to take into account what actually the appellants had said in relation to their developed relationship.
It's almost, as so often the case, it's a reason stroke perversity point, isn't it? Either you had all this evidence about the quality of the relationship, you should either say that's not good enough for the following reasons, which might or might not then stand up, but if you don't do that, it's on the face of it perverse. But it's one or the other.
It's one or the other, yes.
Failure to take into account. Perhaps perversity isn't quite the right point.
I think
more failure to take into account of reasonable consideration.
Which is how I present it. If it strays into perversity, it strays into perversity.
Well, it's relevant to what if we got there, what relief you would get, because you would have to then go back.
Yes.
If it was perverse on the evidence before, you wouldn't have to go back.
Yes.
Does it come to this on taking account of subsequent events, that it may be right to say ordinarily you can't work retrospectively. Suppose that the couple had simply moved in together in November 2020. He hadn't proposed to her. They hadn't given notice to the registrar of wanting to get married. It would be very difficult to say, well, it was a durable relationship. Look, they're still together 5 years later. But you don't have to go as far as that. You rely on evidence evidence of what was done up to and including Christmas Eve 2020. Now, there might be cases where that turns out to be a sham, and but you are entitled to say, well, it wasn't a sham. They did go through with getting married in April, and to that extent, you can take account of what happened later, and you say that unless that sort of evidence is capable of being taken into account, no weight is given to the fact that the rule says marriage or civil partnership for at least 2 years, unless there is other significant evidence. You say it's other significant evidence.
I say it's significant, yes.
You say there is significant evidence, yeah, of exactly the kind
of the durable relationship.
Yes.
Durable doesn't mean 2 years or more.
No.
It will perhaps generally mean something like that, but it's not a bright line rule.
Yes, and of course, in this case, on the facts, this is a relationship that had been in existence for a little over a year. It's the cohabitation that was well short of that. But the evidence before the FTT was, in my submission...
The concept of durability is not just longevity.
No.
It is the character of the relationship.
Yes.
And as soon as you're married, then it is durable, unless it's a sham. But you say it's, on the evidence in this case, having gone to the registrar before the key date, there was enough here, at least, to mean in case the judge must explain why she thought it wasn't durable.
Yes, I mean, to put it in a different context, our submission is there was, whether it's significant evidence or I would submit powerful evidence going towards the underlying substance to the relationship.
And this was a case where they weren't cross-examined at all.
Correct.
I expect you were going to do this anyway, but could you just, either now or when you were going to get to it, just show us, I couldn't quite understand the evidence about going to the registrar, may not matter, but
as far as I can turn my back, I've got my instructing solicitor behind me. But we don't have anything other than what's in the statement.
Okay, well, let's just make sure I've seen the right bits of the statement. They actually use identical words. So if we just look at...
Paragraph 24 of the appellants, that's on page 5 of the PDF, page 6, but page 5 of the supplementary bundle. We contacted the registry office in order to give notice of intention to get married. We were offered an appointment on the 24th of December.
Yes, exactly. It's just, it's a long time since, well, I wasn't married in this country anyway. The appointment, if you didn't know the system, might be an appointment to get married, but I think it means an appointment to come in and see the registrar.
I think that's right, because because he's a foreign national.
Yeah.
Foreign national without leave.
Well,
but then it says we tried to book a marriage date, but that
maybe they didn't have the appointment on the 24th of December because there was another lockdown.
Yes, and with the final sentence says the delay in getting, I mean, the truth is it's not clear and we can all interpret it, but I think the one thing, knowing the system, they're not saying they were going to get married on Christmas Eve and that was postponed.
I certainly can't.
But the procedures necessary to get married had to be delayed, and that was because of lockdown.
Yes.
And that was the Christmas where we were all locked down at short notice, wasn't it?
2020, yes.
Yes. Right, well, I mean, that's really as far as it goes.
Yes.
Because I think she says exactly the same thing.
Yes. So those are our submissions on ground 2. And unless there's anything further from Lordship's ladyship, then that is our case. I can deal with relief if you wish, but
I think probably not at this stage. We might just rise and see where we are. Thank you very much.
Attention, please. Attention, please. This is a security control office. You're now now invited to observe a 2-minute silence to mark the 80th anniversary of the day.
Thank you. I hadn't appreciated the 2-minute silence would be now. I think we should observe it in court. Understand.
Thank you.
We will now rise.
We do have control of is the past version. You know, when you can go on, you can say what were the rules in force at any particular date. We control that, and that's why. And see, this is where this was taken from. This is what I've pointed out myself. You do get the in particular to show that the Secretary of State is satisfied, etc. Is the tailpiece of the whole provision.
I think what I'm minded to do is say that we're putting on that afterwards if that will assist. I think I've given that explanation already and clearly it's not blessed by it. So I think probably in terms of further indentation things, maybe that. Can you just help me though with something that I think they're particularly interesting, which makes sense to me.
In the current rules or the old rules?
Either, to be honest. Let me get my copy of the old rules because we're pretty concerned with that. And where, and let's just say, and where a person comes within that exception, then it starts here, the Secretary of State is satisfied by evidence. It doesn't say, and the Secretary of State must still be satisfied by evidence. Do you see the point?
The person is self-contained, but it doesn't fit in. And then the person holds, and then where the person is being supplied, it doesn't hold. And where?
Yeah.
say dissatisfied.
You see, this is the evidence provided, so it's currently drafted makes it sound as though if these conditions are met, then the Secretary of State is satisfied.
Yes.
Rather than the Secretary of State must also be satisfied that the evidence was formed. You can't just form these durable.
Yeah, that's what we're driving at.
I might have to accept that unless we've got another explanation.
Yeah. Yeah.
They're going to have a go about what.
So with the evidence applied, the durable partner doesn't hold. Anyway, yeah, I mean, obviously this is the definition of who a durable partner is. What we don't have at the start here is a durable partner is.
Yeah. That, even if that was the case, we'd still struggle to
Yes.
fix this bit because it's nested in double two.
Yes.
Just one other question. I'll let you keep looking. It's a bit different. So
No, I think you're right. Don't leave it straight away.
Yeah, they do want our explanation. So we've got 14, which is for family members.
Yes.
And you're just under 14A.
And you're joining family members, yes.
For the purposes, if he had come, he'd been found to be a joint family member on the tribunal. This is 14A, is that right?
Yes, that's right, yes. He didn't, he applied under 14 as a family member for a year.
Yeah, but we would have considered whether he met this definition.
Yeah, I mean, if he had a student visa at the time or something.
And would have thought about it, but
Yeah.
he just doesn't come within the time.
Yeah.
Great. Yeah, I'll talk through that. I mean, obviously, if at least it's all about being covered. I realise I'm going through the track that actually drawing out the distinction between those two things, not that anything really stands in it, but is actually quite key to understanding the structure of the provision and understanding how BBB and CCC fit into that structure. So what I'm going to try and do is make AAA clearer in the context of what it's trying to do in relation to joining family members. That's why I asked the question about why we're under joining family members rather than...
Yes, and as you say, it's an exception to the person being overseas, which is what these things achieve, which is what these other two criteria achieve, but crucially breaking the continuity of residence. And meaning that this person doesn't then have to leave the UK after the end of the transition period solely for the purposes of breaking the continuity, which is what some couples have done.
Exactly. And I don't have a mind of their own.
And we can provide the soft and hard copies later today, if that's all right.
Yeah, if that's okay, if we can get them emailed across, I think ideally if we can do that over lunch or sooner. Do we have? I can get my clerks to send out copies. That's not a problem. I just need a copy that's properly indented. Actually, one thought we don't have the next bit. So that doesn't help. But anyway, we're clear, aren't we? That this is a requirement that the Secretary of State must be satisfied.
Yes, these things being the case.
It's not that if these things are the case.
What, rise and table?
Must be satisfied.
you weren't wanting to say anything else, Mr.
No, my lord.
No.
I was just
Complicated enough by sitting down.
Oh yes, just one small point I wanted to raise with you, just for the future, Mr. Wilding. I didn't want to start by mentioning it. The grounds of appeal in this case, I have a bit of a crusade on about grounds of appeal. So every time there's an opportunity to make the point, they're not what grounds of appeal ought to be. They're 10 pages long. They look like a mini Stellison. If you look most recently at the case of Municipio de Mariana, though it's only summarising a lot of other cases, there is clear guidance from the court that grounds of appeal should be very short, a page or two at most, and all the arguments should be in the Stellison. I'm not giving you a hard time about that, but as I say, whenever I get the chance to get that message across, I take it. So can you bear that in mind for the future?
Of course, my lord. Of course, this case, we got permission directly from the Upper Tribunal, which have different procedure rules, and it just says grounds. There's not an expectation for grounds and separate scales.
Well, no, but once you plead grounds with your appellant's notice in this court, you should follow the practice of this court.
Forgive me, my lord. I thought there was a separate grounds of appeal. I can.
Oh no. Well, all right. Sorry, I really don't want to give you a hard time.
No. I take the point.
Well, if you. There. Mr. Wilding, I owe you a profound apology. And in fact, I flagged it as grounds, but when I was looking at it last night, I must have looked at the grounds below.
Yes.
Wipe the last minute from your memory, and we'll go on to Miss Jackson.
I'm grateful.
These are excellent grounds, may I say.
I'm enormously grateful.
I shall make a point of paying them a compliment in their in the judgment. Now, Ms. Jackson, well, it's fairly clear what the issues are, and they're fairly succinct, and you can take them shortly. But as you will know, there are some points about the structure of these rules on which we particularly would welcome your help. You go ahead, and if you haven't dealt with them all by the end, we'll pick them up with you.
I'm grateful, my lord, and thank you, my lord, my lady. So I was proposing to take my submissions in the following order. Firstly, briefly summarising the Secretary of State's position on the appeal, which hopefully won't come as a surprise. And then, as my learned friend did, deal with ground 2 first before explaining why the Secretary of State's position is that ground 1 will fail in any event. So by way of very brief summary, the appellant has, of course, advanced 2 grounds, and it's accepted that he needs to succeed in both. On the second ground, the Secretary of State's response to Mr. Wilding's proposed construction is that it should not be accepted on a proper reading of the paragraph, both in terms of the words and also read in context. And you have the point that the Secretary of State's position is that the construction advance would be absurd. And I think Mr. Wilding...
Well, no point trailing. Either make the submissions but I think no need to summarise the position, because in 1 minute you're going to actually tell us what the position is.
Okay, well, I'll stop summarising it, but our position is...
Okay, thank you. So starting with ground 2.
Yes, so starting with ground 2, I would like to start by just outlining briefly how the EU settlement scheme regime for durable partners works and the wider origins of that scheme by reference to the decision in Chelik, and then come on to discuss the definitions as they stand in Annex 1, which I hope will cover the territory that you're interested in terms of explaining how the different provisions in relation to EEA family members, but separately joining family members, work. Then I'll address the construction of AAA specifically, if I may come into it in that order. And I'll do so particularly by reference to the decision in Haney, because it's the Secretary of State's position that construction is the better construction. And then I'll deal with certain points raised by Mr. Wilding in relation to the statement of changes and also the significance of the change in the immigration rules to the decision that you have to make. I was also going to address if Mr. Welding did the applicability of the guidance at the time, which is the point raised in his skeleton argument. I don't understand there to be further submissions on that, so I might leave that to how it stood in my skeleton unless I can further assist on.
Just on that, do we have the authorities that tell us about the relevance of guidance?
The relevance of guidance specifically, I don't think I've put any authorities in the bundle. When you say the relevance of guidance, do you mean
as
the relevance
in,
of guidance
in construing? Yes.
I haven't put the authorities in the bundle because I didn't think
it's quite a contentious area, isn't it?
It is, yes.
I know there are authorities, and I think they do eventually settle down to it, but I can't remember what they say.
Indeed, my understanding was that they settled on the point that guidance didn't dictate the interpretation of the immigration rules, but I don't have the I don't have the authorities before me, so perhaps if I could take that away, and if it would be helpful to put in.
Well, let's see. I'm still fairly hopeful we may finish before the short adjournment. If we don't, you can look at them over the short adjournment, and if it's important and we do finish before, you can send us a note afterwards.
I'm grateful for that. I think the Secretary of State's point is that the guidance is consistent with the position. And even if it wasn't, in some respects and not other respects, it shouldn't wag the dog, as it were, in terms of the interpretation of the rules. That I will take that away if necessary. And then finally, I'll just go to the decision in the Upper Tribunal to show how the approach taken.
Okay, yes. Yeah.
So in relation to the EU SS regime for durable partners, I wonder if we could turn up Chelik if. That's okay. It's at tab 16 and page 448 of the authorities bundle. My Lord has correctly identified that the Secretary of State does not say that Chelik answers the issues in this appeal. However, if you would turn to paragraphs 2 to 4, which briefly set out the facts of the appeal, which you can see are that Mr. Chelik entered the UK unlawfully. He formed a relationship. Apologies, I'm jumping the gun. He formed a relationship with an EEA national.
Sorry, where are we reading from the head now?
Paragraph 2 to 4 of the actual judgment.
2 to 4.
Just as a brief summary of the facts. So as I was saying, he entered the UK unlawfully. He formed a relationship while he was here with an EEA national. They began living together in February 2020. Like the appellant in this case, he was unfortunately not able to marry his partner before the end of the transition period, which was due to the COVID-19 pandemic. And different to this case, Mr. Chelik had actually applied before the end of the transition period, but under the EU settlement scheme and not under the 2016 regulations, which was what he was required to do in order to facilitate his residence. And that application had been refused. He applied again under the EU settlement scheme after the end of the transition period on the 17th of March 2021. He then subsequently got married about a month later. There was a bit of a question on chronology, but not that's relevant to us today. And ultimately, the appellant, Mr. Chelik, advanced various grounds which raised the key question of whether he had rights under the withdrawal agreement, despite not having had a residence card prior to the 31st of December 2020 and not marrying his spouse until after the pandemic and after the specified date. And to put it very shortly, the Court of Appeal's answer to his appeal was no, he did not. And the fact that he had not made the application for the residence card prior to the specified date was essentially fatal. So those are the facts of the decision in Chelik. If we turn to paragraph 7, and 7 to 9, I just so I can see how much detail to take this in, have my lords and lady had the opportunity to read these paragraphs in advance, or am I taking to you?
Yeah, no, well, I have certainly read it in advance. I imagine my lord and my lady have. So, I think you can be quite quick with Chelik. I think what is it you get out of it that is helpful to you and to our understanding of the background of the rules generally?
So the key points which are helpful are firstly, obviously, the context of the withdrawal agreement is in the context of Brexit, and Chelik was firm in recognising the firm line caused by the specified date. At paragraphs 10 to 18, which again I'll take quite quickly by just going to paragraph 12, we see what the circumstances were before Brexit and the regime under the 2016 regulations which implemented the Citizens' Rights Directive, which again is important context to where we find ourselves with the EU settlement scheme, which is why I underline it. And in paragraph 12, we have an extract from Article 3.2, which at 2b shows the person with whom the union citizen has a durable relationship duly attested. The host member state shall undertake an extensive examination of the personal circumstances and shall justify any denial of entry or residence to these people. And then paragraph 13, again I'm paraphrasing, draws on the judgment in the Court of Justice of the European Union case of Rahman, which emphasised that any right to reside was granted by a member state, and the obligation on the member state was one of facilitation rather than a standalone right in itself. So it's for the member state.
I don't mind. What this is all interesting stuff. How's it material?
The reason, and I am trying to take it shortly, is because as my learned friend puts his interpretation of ground AAAA, paragraph AAA, he says that the wording is so clear that only an absurd interpretation of the wording can apply. We say that the wording is not so clear that justifies an absurd interpretation, and when one looks at the context in which paragraph AAA falls, and this is part of that context, then we understand why A, the absurdity arises, and B, why that's an unfavourable interpretation of the rules. And the reason I draw this is...
So it's really context helping to show the absurdity.
Exactly. And more than absurdity, to inform why the Secretary of State's position is the interpretation that reflects that not only the wording of the provision, but also the intent and the context in which it forms. But as I say, this is background, and it is set out in my skeleton. So perhaps if I jump forward to discussing the provisions of the EUSS themselves, I'll just go to 30 of Chelic. And from this section on, we see the Court of Appeal grappling with the same definition of durable partner that we're looking at. And we see from paragraph 33, the definition of durable partner up to paragraph AAA being identified. We see at 35 that, and it says there, in short, therefore, a person would be able to claim limited leave to remain as the family member of an EU national if A, the person married an EU national before the end of the transition period, or B, was in a durable relationship, and that relationship was evidenced by the grant of a relevant document, including a residence card issued under Regulation 18 of the regulations. At various points in this decision, you have it very much underscored that it is indeed the need for a residence card that is absolutely critical. And if we jump to 68, which deals with that point, it says, starting from the second paragraph, that the fact is that the appellant was not a family member at the material time, he had not married an EU national before the cut-off date, he was not a durable partner within the meaning of Annex 1 to Appendix EU, as he did not have a residence card as required, and he did not have a lawful basis of stay in the United Kingdom. He was in the United Kingdom unlawfully. And the Court of Appeal in that decision arrived at that conclusion, A, by looking at the words, obviously, of the definition of durable partner, but also in considering the various points that were raised in relation to its context and the withdrawal agreement and the EU law that had come behind it. And so I just wanted to show the court how the court in Chelic had approached these issues and had arrived at the conclusion that, put in quite broad terms, the fact that he did not have a residence card meant that he could not be a durable partner of an EEA family member. So I'll pause there for a second because, as I acknowledged at the start, what this case doesn't address is the question of whether Mr. Chellick was a joining family member within or met the meaning of paragraph AAA. And so I think it would be helpful at this stage if we could look at the rules themselves. And I'll go to the ones as they stood at the time of the decision that was at the time of the application and the decision in this case. But in the bits I'm about to go to, there's not been a material change. So if I could go to tab 2, page 160. Of the authorities bundle letters. So we have at the bottom of 160 EU 14, and that is the provision that concerns the eligibility requirements for limited leave to enter or remain for a person who's applying. And if we look at condition 1 in the box, 1A, 1 and 2, but there are others as well, a relevant EEA citizen or a family member of a relevant EEA citizen. And it's in the second one that potentially we might be looking at here when it comes to this appellant. If we then look at EU 14A, which comes beneath that in on the same page, we then have the persons who are eligible for limited leave to enter or remain as a joining family member of a relevant sponsor. And you can see, and I'll give you a second if that would be helpful to have a look at the criteria, but essentially the key point that we're looking at in relation to AAA is whether the appellant is a joining family member of a relevant sponsor.
So I've got confused. Ultimately, this application is made under EU 14, not 14A, is that right?
It was, yes. And the reason why we're not pursuing any particular point about this is because, as I understand it, if a person were to apply under EU 14A, EU 14,
yes.
EU 14, would come within what the Secretary of State says paragraph AAA entails. So they have not had facilitation of their residence.
Sorry, no, I think we're going too fast. This is very helpful. You've gone right back to the first building block. We haven't gotten anywhere near AAA at the moment.
Of course.
So at the moment, we're looking at EU 14.
Of course.
And I assume what you were going to do was then take us the definition of a family member of relevant and walk us through till we get to AAA.
Yes. Apologies. I can
But
address
but I wasn't quite clear why we were looking at 14A at all.
Because 14 addresses the provision for those who apply as a relevant EEA citizen. As I'll come on to...
No, a family member of a relevant.
A family member of an EEA citizen,
Yeah.
but not a joining family member. So 14,
Yeah,
you're
exactly.
dealing principally with applications from people, I think entirely for applications with people from inside the UK.
Exactly.
In 14A, you're dealing generally, and the generally is intentional, with people applying from outside the UK to come to the UK. The reason why it's generally is there's a very narrow class of people who have been living in the UK, who were living in the UK in a durable relationship prior to the specified date, who never made a 2016 regs application for facilitation, therefore never had a residence card, but had another lawful basis to stay in the UK. So, for example, were in the UK as a student, never needed to apply for a residence card, therefore never formally could meet the standard Chellick definition of an EEA family member, never can meet the definition of an EEA family member full stop, but they may be able to come within the definition of a joining family member, and that's where we get into AAA.
So, sorry, just to summarise that, EU 14A is generally for people applying for abroad.
Yes.
So your narrow exception, which sounds like what you say AAA
Exactly.
is all about,
Exactly.
is people who are in the UK, they did have another lawful basis, they didn't make an application under the 2016 regs, because they didn't need to. So that precisely corresponds to what you say.
Exactly, and that is why I was slightly
But you
jumping
also
the gun.
say they might then fall within the definition of a joining family member, which goes back to one of the questions I asked right at the start, and I still think I need a bit more help.
It does.
I'm not there yet. But let's come back and look at joining family members in a minute. But the moment, to be quite clear, ultimately, his application is under EU 14, not 14A.
Yes.
And therefore, he has to show he's a family member of a relevant EEA citizen.
Exactly. But the reason that the Secretary of State hasn't taken a point on that basis is because if...
Well, what point is there to take?
Well, that he only applied as an EEA family member, and therefore AAA cannot apply to him because it only...
Well, I think you've got to... Wait till we got to the end, then explain. At the moment, I don't understand what you're saying. Just take us through the stages. So, stage one, family member. So then we look at the definition of a family member.
Exactly. But I think there is one point that, if I may, I'd like to make, which is that if a person were to apply under EU 14, they actually don't meet the definition under EU 14, but actually the Secretary of State, when looking at their application, sees that there is material that suggests that they could come under 14A and meet the definition of a joining family member, and the Secretary of State would take it upon herself to make that consideration. We say we don't get into that territory because this appellant simply did not meet the definition of joining family member. I just wanted to draw that out because, yes, this appellant applied under 14, that EU 14, that wouldn't have excluded him for consideration.
It's right, is it? The application has to specify which rule, what you're applying as, does it?
The application, I think, I actually had to look, apologies, just let me know. Is that correct? Okay, thank you. I think that's helpful. Yes, I've been told that it does require you to specify whether you rely on residence up to the end of the transition period, but it doesn't require you to specify particular provisions of the immigration rule or whether it's indefinite leave or leave or limited leave.
All right.
Is that right? So it wouldn't be the case necessarily.
So your application basically just sets out this is the kind of person I am.
Exactly.
These are my facts, and the Secretary of State does the correct legal analysis for it, decides whether it's LLR or ILR, and decides whether it's 14 or 14A.
I think in relation specifically to those two examples, ILR or LTR, or whether it's 14 or 14A, yes, it is correct that the Secretary of State would make that decision. I don't know about other matters.
Apply this to an analogy to the facts. If the appellant did have a lawful basis to stay, then the fact that he might have been seen perhaps as applying under EU 14 wouldn't preclude the Secretary of State treating him as capable of falling within AAA, even though he hasn't characterised himself as a joining family.
So say he had his own student visa, and that was part of the factual matrix that he put to the Secretary of State, or the Secretary of State would be aware of that, then the Secretary of State could then go on to consider whether the definition of joining family member was met, which I hope assists in explaining why the Secretary of State doesn't set much by the specific provision that was the gateway to his application and refusal. But our point is simply that the joining family member provisions don't arise.
I'm sorry if I'm behind the curve, I'm sure I am. He doesn't come within EU 14 because he's not lawfully resident. Is that right?
He doesn't come in EU 14 because he's not a family member of an EEA citizen, and perhaps this would be a good moment to now go to the definition of family member of an EEA citizen, which we have at page 181. And it starts right at the bottom. The very short answer to your question is he's not a family member of an EEA citizen because he doesn't have a residence card. And we see that from the structure here, where, and I'll just take us through it. I know we've been through it several times, but I hope that this.
No, we haven't been through it several times. So
sorry, we of course we haven't been to it. In that case, I will take you through it. A person who does not meet the definition of joining family member of a relevant sponsor in this table, annex.
So do we have to look at that? The first thing we have to do is look at that definition, don't we?
We do. If I may carry on, notwithstanding, because I think it's a slightly unfortunate feature of the annex that there are lots of interrelated definitions.
All right, but sooner or later
if we take a hypothetical that we're not looking at a joining family member of a relevant sponsor for the purposes of understanding this definition, and we carry on, who assessed by the Secretary of State, including by the required evidence of family relationship.
Is that a defined term?
That is a defined term, but again, I maybe would rely on the same point, and I don't think specifically here the required evidence of family relationship is something that that necessarily we need to go into.
No, but we may or may not need to. I just like to understand these things. Just so I feel I've got firm ground under my feet. What is the required evidence of a family relationship? Is it
Page 214.
Yeah. Yes, sorry. Thank you. No, I am being assisted. In this case, it would be the residence card.
Yes, I see. Thank you.
Sorry, where do you get?
My lady is saying, just show us. I'm sure you're right, but why? Is it E on page 216? I'm not necessarily it is, I'm just asking.
Yes, okay, thank you. So it's under R, required evidence of family relationship.
Oh.
214, thank you.
Sorry, I misheard you. Where exactly are you looking?
So at page 214, the box required evidence of a family relationship.
Yep.
And then we have A would relate to spouses.
Yeah, there's got various different groups of people. I would suggest it might be E on the next page.
Yes, I'm so sorry. I didn't hear didn't hear that. That's quite right. It is. Okay. Right. I am also unfortunately getting onto the definition. So it would actually I'm being insisted to be A because they were married at the date of the application.
Oh, I see.
So we'd need the relevant document as the spouse, and then in BB where the marriage to the qualifying that's the British.
Sorry, you're complete. Just take your time. Tell us what we need to look at in order to see what the required evidence of family relationship.
Yes, it's A2AA, where the marriage to the relevant EEA citizen, or as the case may be, the relevant sponsor, was contracted after the specified date, and the applicant is not the specified spouse or civil partner of the citizen. A relevant document as the durable partner of the relevant EEA citizen. So that's the provision that we're in.
Okay.
Right.
So sorry, going back then to the definition of a relevant family member. Relevant. We're assuming, although you haven't shown us at the moment, that they don't meet the definition of joining family member.
Yes.
And they've got to have satisfied the Secretary of State.
Yes. Sorry. Just to complete that, at page 222, the specified relevant document is defined, and in this case, it would be the relevant.
Sorry, what are you saying?
So the definition we were just looking at also had a defined term, which was specified relevant document. Sorry, relevant document.
Oh, I see.
And we only need to focus on residence.
We only need to focus on residence card.
Okay.
So if we go back,
sorry, I'm struggling again. Step 1, EU 14, A 1A little 2. Applicant, family member of a relevant EEA citizen. That's a defined term with the definition stretching over a page beginning at the bottom of 181.
Yes.
By the time of the application, he's the spouse of a relevant EEA citizen. So then we're into durable partner under A2.
Exactly.
Yep.
And then durable partner of the relevant EEA citizen is the next. Is that the next stop on the?
It is, yes, and then we're back to 175 where we have that definition. Now,
Okay, well that's helpful. So that's how we get to 175.
exactly.
You have. I'm not going to make you do it, but the one thing you haven't yet done is show us why he is a person who does not meet the definition of joining family member.
Well, I would like to go there now.
Okay.
I apologise for taking in that.
No, it doesn't matter at all.
Just because 14 is EU14 is where we've started. So now I would like to go, if that's okay, to the definition of joining family member at 187. And so again, I wonder if it's more helpful if I give you a minute to just have a look at the provision before I put my explanation on it.
Okay. Need more than a minute to understand it properly.
So,
but
yes, which parts? Because when you start looking at it, you start thinking, well, he may be because
Yes.
he's the spouse,
So,
ignoring the relevant sponsor definition, another definition, and on his case was the durable partner before the specified date. That's A double B.
yes.
But it isn't. I think the answer, but am I going too fast? Is on page 188. You've got another set of A's to E's. I mean, shockingly confusing. But these are further requirements. So these are the ones that really deal with the joining element.
Exactly.
And the basic one is you weren't in the UK at any time before the specified date.
Exactly. So I think.
So that's the core. That's what makes you joining, because you've got to come here to join. But obviously it's more complicated than that, because there are some circumstances where you are in the UK before the resident date. That's what B is. But something has happened.
It might be helpful if I explain broadly how
Yes.
this provision works, and then if we need to go more into the words to follow that through, it might be helpful to do that with the framework. But broadly, my Lord puts it correctly, this is a provision that principally deals with people applying from outside the UK, and there are certain exceptions to that. And one may come within the provisions of being a joining family member if, at the relevant time, the person was a spouse or civil partner, and the marriage was contracted prior to the specified date, or, which is where we are at ABB on the first page on 187, the applicant was the durable partner of the relevant sponsor before the specified date. So that's how this provision works. But under both the joining family member provisions and the EEA family member provisions, we funnel down to the durable partner definition. And so if the appellant is able to meet the definition of durable partner within, and I accept that we're now going to have to go to AAA and see how this works, but if the appellant meets the definition of durable partner for the purposes of being a joining family member, which is where the Secretary of State says AAA is situated, and can then come within the definition of a joining family member of a relevant sponsor, then they may be entitled to leave under EU 14A.
Okay, but I'm still a bit confused because you said earlier that taking the opposite case, the appellant with the student visa, you said you might be able to treat him as a joining family member. Looking at the additional requirements that my Lord has referred to from page 188, how would you? Because he's in the UK.
So I can hear the answer behind me. So if we look at A, the second A on page 188, and it says, in addition, the person meets one of the following requirements. And then it says they were not resident in the UK and Ireland on a basis which met the definition of family member of a relevant EEA citizen in this table. And that is the way in.
Oh, so they were resident, but on another basis.
On another basis, exactly.
Yes, I see. Yes.
Exactly.
So it's this concept of being resident on a basis, which is seen both.
Exactly.
Right.
And so you end up with, if I may call it such, a slightly artificial situation where someone who was in the UK and was resident in the UK, but not as an EEA family member because they had a different basis to remain, is treated as, well, will become a joining family member and is artificially therefore treated as though...
Now, I'm not trying to, for once, I'm not trying to get at the drafting. I just want to be clear about this. So, in fact, the phrase joining family member is counterintuitive. It doesn't actually mean someone who is abroad and wants to come here and join. It might mean that.
It almost always will mean that.
But it doesn't, that's not the essence of it.
Exactly, and that's why I said generally it would apply to people applying from abroad.
Okay. Well, I think, fortunately, we don't have to write an essay on this. We just need to understand how it all fits together. So, if we can go back to... my Lord and my Lady want to do it some other way, we will. But going back to the family member of a relevant EEA citizen, which is the first definition in the cascade of definitions we have to follow. In a sense, you want, but because the first element in that definition is not being a joining family member, in order to find out whether you are a family member, you have to look first to see whether you're a joining family member. Because if you're a joining family member, this definition doesn't apply.
I think that does follow. Yes.
Okay. So, I previously thought I understood that it was common ground for the purposes of this appeal that this appellant is not a joining family member.
I think it's the Secretary of State's position that this appellant is not a joining family member because he doesn't come within the definition. I think if it was common ground before this appeal, then that assists the Secretary of State's position. I hadn't necessarily understood the appellant's position.
No, well, that's fine. My lady raised this early on because there are some references in the earlier history of the case to issues about whether he's a joining family member, and also because we want to get this right. If we say something as part of the background to this that gets it all wrong, that will be a disaster. There'll just be more litigation. So, of course, we ultimately got to decide the point in this case, but because these words appear in the definitions we're looking at, we want to be sure we understand what they mean. Is this a fair summary, though, of where we're at? The case is now, at least, whatever may have been the case in the past, proceeding on the basis that he is not a joining family member, therefore that the relevant definition is that he is the relevant definition, whether or not he satisfies it, is the definition of a family member. Ultimately, however, in square brackets, it doesn't make much difference, because whichever definition you apply, you get back into them having to be a durable partner, and you'll get back to AAA by a different route.
I think if we go to AAA, it might hopefully become...
No, just tell me whether I've got that right. If I got it wrong, then we must explain.
I mean, from the Secretary of State's perspective, and I'll be corrected if I'm wrong, I mean, that would be a helpful way for us to look at the appeal, because we say he's certainly not an EA family member because he didn't have a residence card. And if it's then common ground that he can't be a joining family member, then we don't get into the territory of looking at the interpretation of AAA.
Okay, so that can't be common ground as such.
Which is why I didn't understand it to be common ground.
Yes.
Which is...
But we're not hearing any particular argument on it.
Yes, well, I'm still trying to say that. If we can go to durable partner definition, I hope I can make clear.
There was nothing in Mr. Wilding's oral submissions, perhaps because we put him off it, but I don't think, let's have a check, there was anything in his skeleton argument that said this was a claim that he qualified under 14A.
No, I don't think there is, and as I said, this is a point that the Secretary of State we did raise in the skeleton, but and apologies for my drafting, and that I didn't set it out so clearly in the summary of what the provisions were, which were engaging with what the appellant had said, and we drew the point out in response to this ground. But I mean, I can take you through, but I think at this stage, dissecting my own skeleton to show that these are points that we've made before.
Where in your skeleton do you say?
So
I have the reference.
If we go to ground 2. Paragraph 47 onwards, I addressed the second point about the construction of the provision. And at 50, in relation to the law for basic status, it's actually not a provision.
Sorry, you're dropping your voice.
Apologies, just allow me 1 second if that's okay. Yeah, so paragraph 22, the Secretary of State makes the point about the distinction between durable partners and the rules for an EEA citizen.
Sorry, can you speak up?
Apologies.
You're speaking to your desk rather than to us.
At paragraph 22,
yeah.
We draw the distinction. And then at 28, we pick it up again about this being a paragraph that applies to an application for a joining family member. And at paragraph 9, again, we emphasise about joining family members.
29.
Did I say 20? Sorry, 29.
Yeah.
You're quite right, 29. And then again at 65, we refer to the guidance that was applicable at the time and the distinction that was drawn there as well. So again, I would say that the Secretary of State has fairly drawn the distinction, but as I said at the start, we don't say that we never would have considered his application if it had not been made on the right basis, but it does come to our interpretation of how paragraph AA works within the framework of a scheme that draws a distinction between EEA family members and joining family members.
Well, perhaps this is the point to get, if we're not going too fast, is this the point actually now to go back to the definition of durable partner?
That was where I was hoping to go. So if I could take you back to 175. The authorities bundle. So This we have looked at, but I will take it from the top, just because I think part A often gets forgotten, and sometimes it's kind of helpful to understanding why the judgments are the way they are. But paragraph A requires that the person was in a durable relationship with a relevant EEA citizen, for our purposes, or with a couple having lived together in a relationship akin to a marriage or civil partnership for at least 2 years, unless there is other significant evidence of the durable relationship. So that's A. And I emphasise that because to remind that even within the context of this provision, the decision maker does still need to consider whether the relationship criteria was met. So it's not the case simply that a residence
durable
card,
relationship is not a defined term.
It is not, because I think that's correct. It's defined in it's the definition is internal here. So the durable relationship with the couple, it says with the couple having lived together in a relationship akin to marriage or civil partnership for at least 2 years, unless there's significant evidence. So that is what durable relationship means in this context.
Well, I'm not sure that's right. It doesn't matter, because the parenthesis, unless there's other significant evidence of the durable relationship doesn't just mean 2 years.
Sorry, I'm including that. Yes, I see.
Okay, but the fact is, the word durable relationship is not defined.
Indeed.
And that you've just got to use your common sense and case law and all the rest of it. Yeah.
Yes, no, I see the point.
Okay.
But
so A, it's got to be a durable relationship, and B,
yes.
And this is where we're getting to documentation.
Exactly, and this is where we start seeing the distinction between the EEA family member and the joining family member come out. So B1, the person holds a relevant document as the durable partner of the relevant EEA citizen for the period of residence relied upon, and then what follows is a deeming provision which simply allows it to be treated as a person having had the required document if they'd made the application.
Yes, that's the deeming about the application. Right.
So that's where we were in Challenge. We were only in this paragraph, B1. The person, in that case, Mr. Chelick, did not hold a relevant document, and therefore he did not meet the definition of EEA partner. Then we get into Roman numeral 2, which is the or. So already we're in circumstances where a person does not have have the required document, in this case a residence card, showing that they're in a durable partnership. And it says where the person is applying as the durable partner of a relevant sponsor, and then some other bits that don't matter, and does not hold a document of the type to which sub B1.
No, sorry, because this is the first reference to joining family member.
Yes.
Yes, sorry, I'm skimming over.
You get there by the definition of relevant sponsor as well.
Exactly. So where the person is applying as the durable partner of a relevant sponsor. So that is where we come into the definition. So relevant sponsor, we've takes us to the definition we were just looking at of joining family member of a relevant sponsor at page 187.
Well, does it? Applying as the durable partner of a relevant sponsor. Surely we have to go to definition of relevant sponsor, which we haven't yet been to.
Yes. Sorry. I'm being reminded you. So you can go to relevant sponsor, which is
where's that?
Definition.
Where's that?
It is at 205.
We haven't looked at that yet.
We haven't looked at that. I apologise.
Don't worry. Odd.
It's all written in terms of joining family members, as I say it.
It is.
So there's two principal provisions, A and B.
Indeed. So we have the relevant sponsor, who's essentially the anchor, being, in this case...
So it says who all the sponsors are. Then we've got some in addition points. Sorry, I have to laugh. In addition, A, in addition B, notwithstanding what is said above, so does this follow that the concept of a relevant sponsor is only a relevant concept for people who are joining?
Yes, that's correct. Yes. Yes. So the two work together. A relevant sponsor will be sponsoring the joining family member. The relevant sponsor, who in this case would be.
So if you have, I see. So if you have a family member, but not a joining family member, the concept of sponsor isn't used.
Exactly.
Okay.
Slightly why I skimmed over it, but here, yes, the relevant sponsor will be the EA citizen who has had their status recognised under the EU settlement scheme.
Yes. Well,
Joining family
then
member.
does that then mean that 2 is only concerned with joining family members?
Are we in durable partner definition?
Yeah.
That is the Secretary of State position. Yes.
Which was my question.
Yes, exactly.
Which.
So yes, 2 is only dealing with durable partners of a relevant sponsor. It's only therefore dealing with joining family members, and joining family members who do not have the type of document to which subparagraph B1 applies. So joining family members who do not have a residence card or another required document. And then we get into the subparagraphs.
So I just want to work out the consequences of this.
I think you're saying that it doesn't ultimately make a difference because all roads lead back to AAA.
Yes, essentially.
Yes, I thought you were saying that earlier, but you disavowed it when I put it to you.
I didn't disavow it. I
mean to.
think the way you put it to me was about it being common ground that
I see.
he was not a joining family member, and you can see where.
Oh, well, don't worry if you disavowed it. The important point is you are saying it does. Is this a fair summary of your position? That it doesn't ultimately matter whether he is a joining family member or a vanilla family member, because in either case, it plugs into the definition of durable partner.
Exactly. And apologies for having to set all of that out before.
No, don't worry. And therefore you get to AAA.
Yes. So if AAA can be met, we then kind of cascade upwards, such that he would.
Well, but suppose he is a vanilla family member. Sorry?
He can't be because he doesn't have a residence document. He doesn't have the required document. Because the exceptions at 2 to not having the required document only apply if you're a joining family member.
So let me just be clear about this. A cannot succeed in this case this is the big picture stuff because he is not a, why am I using the phrase vanilla family member? Because he has no residence card, not a vanilla family member under EU 14. 2, he is not a joining family member. Under EU 14A because of AAA. So in fact, AAA, which is all we've all thought this case all about, is only relevant if he's a joining family member.
So AAA would only be relevant if he's a joining family member. I think the emphasis I would put would be slightly different just in terms of the operation of the rules. If he could come within the definition of AAA, then he may be able to come within the definition of a durable partner for the purposes of the joining family member aspect of the provisions, and then he might be able to come within EU 14A.
Yes.
Yes.
I think that's what
So-
I may have put it the wrong way round.
But I think so you're saying treat AAA as the starting point, as it were. He needs to pass that gateway to get within the definition of durable partner.
Yes,
If he does, he could then be treated as a joining family member.
exactly. If he met the criteria for that, and then he could be granted.
And then
under
strictly it's
14A.
14A, not 14.
Exactly. And that's what I was trying to capture with the kind of cascade if we start from AAA.
We should,
Well, I'm completely baffled by that, I must say, Miss Jackson, but I'll go away and try again over the lunch
Oh, I see what the
hour,
time
but
is, yes.
I
Well,
do-
we've got lunch to try and work it out.
It doesn't seem to me to make any sense at all. But,
Nor does it seem to correspond to the skeleton arguments.
how
All the
it-
way it was argued below. But
How anybody else is supposed to understand this, looking at these rules, whether on the internet or not, I don't know.
I'm not. We will. I think at the end of your submissions, I'll just come back to the point about the note we might want. Because that's not something you can do over lunch. One thing you can do over lunch, if it is the case, is obtain a printout of the new regs in the same format as we have the old regs, in what I've been calling PDF. It may not technically be PDF, but looks like a printed document rather than an internet screen.
I'll do my best.
Okay, thank you very much indeed. 2:05.